Is he valid enough? Is he competent enough to be a part of the contract? If he is not, then automatically the contract will become invalid. According to Indian Contract Act, in certain special cases, the agreement must be returned. In some cases, like contracts by companies selling or buying of shares, the contract must be registered. Good morning and welcome to the second session in commercial law, where we are going to speak about the contracts. In the previous session, we were speaking about the various factors that are involved in a valid contract. So moving further, we are going to start now with the lawful consideration factor. Now, what is a lawful consideration? Consideration is something in return. Consideration has been defined as the price that is paid by one party for the promise of the other. So let us try to understand this consideration first, and then let's move forward with a very small example. Now let's look at the example. X agrees to sell his motorbike to Y for 1 lakh rupees. Here is Y's promise to pay that 1 lakh in consideration for X promise to sell the motorbike, and X promise to sell the motorbike is consideration of Y's promise to pay the 1 lakh rupees. To make things very simple, I have made a promise to you that I'm going to sell my bike for 1 lakh rupees. So that's what I am saying it to you. And you also agree that you will buy the bike from me for 1 lakh rupees. So now look at the consideration. For my side, I am selling the bike, and from your side, you're going to pay 1 lakh rupees. So there's a consideration made. So when I sell the bike and when you give me the money of 1 lakh rupees, the agreement is completed. So that's what we say here. The price paid by one party for the promise of other is called as the lawful consideration here. This is very, very important part of the contract. Moving further, capacity to contract. This is very, very important factor. Why? Because it means that the parties to an agreement must be competent to contract. A contract by a person in an unsound mind is void ab initio. Can I make a contract with a person who is not mentally stable? The answer is a definite no. Why? Because the contract law says very clearly, only when two parties are in a position to contract, are in a sound mind framework, then only they can get into contract. You should have the capacity to contract. So if I start putting my contract agreement with people who are minor, or who are people who are not even in the position to contract, there is absolutely no contract formed at all. So that is why we always say that you need to understand the party from the other side. Is he capable of entering with you in contract? That is very, very important here. So that is why we say this as a part of the contract. So if you go and join hands with people who are not a part of it, then automatically the contract itself will be considered as void. Now, example, X is a minor, borrowed rupees 8,000 rupees from Y, executed a mortgage of his property in the favor of the lender. Now, this is not a valid contract because X is not even competent to contract. X is a minor. So how can he even get into the contract factor altogether? So that is why we say it very, very clearly here. Who is the person who is getting into the contract? Is he valid enough? Is he competent enough to be a part of the contract? If he is not, then automatically the contract will become invalid. Moving further, free consent. Now, what is a free consent? That means if I come and put a pressure on you and make you sign on the contract, that means it will go against the contract. Now, for example, I want to get a property registered in my name. If I go and put pressure on the opposite party, that is the seller, by threatening him to life or by making him sign on a gunpoint, then automatically the entire scenario changes. The contract becomes invalid. So that is what is written here. For a valid contract, it is necessary that the consent of the parties to the contract must be free. They should not be under any threat or any pressure. For example, X threatens to kill Y if he does not sell the car to X. So now what happens is that X is a person who goes to Y and he says, if you don't sell the car to me, I will kill you. Now with that kind of factor, Y gets afraid and what he does is that he agrees and sells his car. But now what happens is that Y's consent was not obtained. It was done under a threat, under a pressure, under a life-threatening situation. So this will not be a valid contract. So if it is proved in the court of law that the entire thing was done under a pressure, under a threatening situation, this would be called for an invalid contract. Now, lawful object. The next thing that we have to learn is the lawful object. It is also necessary that the agreement should be made for a lawful object. Every agreement of which the object or consideration is lawful which is unlawful, is illegal and therefore void. Which means to say that anything which is not considered to be legal, which is illegal, which is not a part of the norms, which is not a part of the society or the business, is considered to be an unlawful object. So that is why we say that whatever in which you are doing the trade, in which you are considering the contract, in which the parties are getting involved, should be about a lawful object. Suddenly you form an agreement saying that we will do business about drugs dealing or gold smuggling or diamond smuggling, or we are going to steal plutonium from Russia. Now let's say that we are going to do something which is completely illegal, where we are going to migrate across the borders without proper legal permission, then it is considered to be an unlawful act altogether. Now, the next thing is the possibility of performance. If the act is legally or physically impossible to perform, now I am putting that words very, very clearly, the agreement cannot be enforced by law, which means to say that, now for an example, A agrees with B to discover treasure by magic and B agrees to pay 1,000 rupees to A. Now, this agreement is void because it's an agreement to do with an impossible act. So suppose you are going to do some Harry Potter story for me, a magic kind of a thing, and then you say that I will find treasure for you from the moon, then this is not a valid contract itself, because these things are not something which is practically possible to perform. So these kind of agreements where I do a magic or some, a genie is going to come, an angel is going to come and some sort of effect is going to happen, will not be a part of the valid contract. It has to be something which is practically possible to perform, followed by not expressively declared void, which means an agreement must not be one of those which has been expressly declared to be void. That is, now suppose he has been told very clearly that it cannot be done and you take it up, which is not being told enough. Suppose there is something which has been already declared as void and then you do upon it, it cannot be considered at all. Legal formalities like writing, registration, etc. A contract may be oral or in writing according to Indian Contract Act. In certain special cases, the agreement must be written. In some cases, like contracts by companies selling or buying of shares, the contract must be registered. We always believe on this fact that anything must be documented properly. So again, when it comes to the Contract Act, the documentation says it very, very clearly clearly here that it should be legally documented. It should be told what it is. Then only it must be registered. You cannot do something where you just talk and go. It has to be documented. There has to be a legal binding. Now, in the case of the share market, when you buy and sell shares, there are going to be some contract registration altogether. So that's how you will register, saying that, sir, this is the value, this is what it has been registered, this much is what I bought, this is what I sold. So all those factors must be mentioned here clearly. So that is what we say as the legal registration factors here. So that is how you will go in terms of understanding the law altogether, and then you will be able to understand and write. So whenever we are going to consider the legal formalities, the written documentation is always mandatory, which specifies under what terms and conditions the contract is being executed. Followed by the types of contract. Now you will be able to see the mode of formation: express, implied contract, quasi contract, or an e-contract. So there are different levels which we will be seeing it in the upcoming sessions. So when you are explicitly told, when it is an implied meaning, when it is a quasi contract, a partial contract, or an e-contract, that is digital kind of thing. Based on performance, the executed contract, executory in nature, partly executed or partly executory in nature, unilateral contract, which is one way, bilateral contract, which is on the other side, which is executed by both parties. Is it a valid contract, a void contract, voidable in nature, which can be avoided? Now the illegal agreement, when we talk about the unenforceable contract, which cannot be enforced by the law, and certain contract which is being done in terms of writing. So when you look at it, these are the types of contract, these are the factors based on the mode of formation, the performance, the validity, or enforceability. Now, let's try to understand each one of them. Let's go into it by express contracts, a contract which is made by word, spoken or written. Now, where is that? Section 9 of the Indian Contract Act provides that if proposal or acceptance of promise is made in words and the promise is said to be in express, which means, yes, I agree to it. If that's going to be the condition, it is express, which is word, written or spoken, then yes, that is what we say it as express contracts, where A says to B, will you purchase my bike for 20,000? B says to yes. Yes, that means to say that moment when you express your answer, that also becomes an express contract. Now, implied contract. Implied means that a contract inferred by the conduct of the person, the circumstance of the case, which means to say that by nature, the law is implied contract through the parties that is intended. Now, for example, let's just go here. A stops a taxi by waving his hand and takes his seat. At the end of the journey, you are supposed to pay that factor. Now, moment you get into an Ola auto and when you get down at the junction at the desired destination, automatically you need to pay for the services that you have taken. That's an implied contract. In a very simple manner, you get into a bus and you go to a particular destination. It is mandatory. It's an implied contract that you have to purchase a ticket for the journey. These are all the implied contract altogether. Now, a quasi contract, which means it's a type of contract where the rights or obligation do not come in from an agreement or an operation of law. Now, for example, Mr. A leaves his good at Mr. B's shop by mistake, then it is not for Mr. B to return it or compensate. Why? Because there's not a formal agreement. Mr. A had forgotten and left his goods there. So that means it is not mandatory for B to take it up under his particular commitment and return it back. On the other side, an e-contract is one which is made through digital signature, that is through internet. Now, for example, whenever you see Amazon, Flipkart, when you just tick on the box, you say, I agree to the terms and condition, and when you hit the submit button, these are all the e-contract examples. With this, I come to the end of this particular session. I hope and believe that all the slides and the resources that we have discussed will be of a great help to you. In the upcoming session, we shall learn more about the essentials of valid contract, which will make the session even more interesting. Until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.